Good morning, Ruslan. Welcome to stage 2 of the selection for HQCJ, the interview stage. Your interview will be conducted by all of our commissioners, including Ted Zazhachny, Ms. Sydorovych Ruslan, Robert Bergeisen, Stephen Markman, and Yevhen Mezintsev. The rapporteurs for your interview are Ted Zazhachny and Sydorovych Ruslan. Should for any technical reasons your interview be interrupted, we will resume it on a different day and at a different time, and we will reach you to reschedule the interview. The commissioners will be asking you questions, and we are kindly asking you to be precise in your answers. A commissioner asking you a question has the right to limit the time of the answer. But before we start with the interview itself, we will give you the platform for self-presentation. You will have the opportunity to tell us about your motivation and the ideas that you have with regards to the work of HQCJ and the judiciary in general. With this, I'm passing the floor to my colleagues. That's Serhiy, you're welcome.
Thank you, Ivan. Good morning to you, Mr. Sydorovych. I'm going to take a moment to review very briefly your history, and in particular your experience in the law, and introduce you to the rest of our viewers. You are 48 years of age, sir, I understand, and you have experience as a lawyer in the law for the last 20 years. You are married, you have 2 children, and in 2014 you were became a member of the Parliament of Ukraine, the Verkhovna Rada, and continued in that capacity as a member of the Committee on Legal Policy and Justice and the head of the Subcommittee on the Implementation of Decisions of the European Court of Human Rights. So you certainly have experience both as a lawyer and as a member of the Ukrainian Parliament in matters associated with the administration of justice. With that, sir, I'm going to turn matters over to you. Perhaps I have been too modest in your introduction, and I welcome any further information you can share with our viewers and with the members of our commission, and in particular your motivation for now seeking a recommendation that you be appointed a member of the High Qualification Commission for Judges of Ukraine. The floor is yours, sir.
Good morning once again. Thank you for the introduction. I would like to add some details to what you have already told about me. So, I started my career in law in 1994. In 1998, I got my license to practice law. Yes, indeed, in 2014, I became the People's Deputy of Ukraine, but my lawmaking activities within the parliament dealt almost entirely with the issues of law. That's why, for me, I believe that I've been in the field of law for almost 30 years. Indeed, I worked within the Committee on Legal Policies and Justice. I was a member of the commission that developed changes to the Constitution. I was also a member of the Council on the issues of the judicial reform. I participated in the development of new procedural code, the law on the judiciary and status of judges, the law on the Constitutional Court of Ukraine, and I was involved in the development of other draft laws pertaining to the judicial reform. And for the first time in history of Ukrainian Parliament, we created the subcommittee for the enforcement of the decisions of the European Court for Human Rights. Why I insisted on creating of that subcommittee? Because I realized that it was an issue for us. On many occasions, the European Court for Human Rights emphasized that non-enforcement of court judgments was a token of lack of efficiency within the judiciary. judiciary. I also was involved in the development of procedures for the enforcement of judgments of courts, and my team also was involved in the adoption of the electoral code of Ukraine. So my activities within the parliament, my lawmaking activities were closely connected to law. And as my friends often joke, you did not become a politician, you remained a lawyer. For me, as a professional lawyer, this is a plus rather than a minus. Before the year of 2014 and starting from 2019, when I returned back to my profession as a lawyer, I've worked with many people. I will not be disclosing any details. I'm currently working within a law firm, and when we were hiring people, we were using some of the criteria that are applied when selecting judges. And within the selection of judges, lawyers and prosecutors, we were viewing the German model for selecting people. My personal motivation, should I be appointed as a member of HQCJ, is to return back to the profession and to see a much better quality of our judiciary by selecting lawyers of a better quality. That's my conviction, that in order to improve the quality of the judiciary, we need to have better quality of people that we select. And the body selecting these people should not have any political motives. It should punish those who are guilty, and it should select those who are the best. Since I have vast experience in recruiting people, I believe that the importance of an interview is really great. And if we are talking about an interview, I would probably even consider having 2 interviews, but that is maybe me jumping the gun. But I think that some selection procedures can and must be improved. And in comparison with the year 2016, when the law on the judiciary and the status of judges was adopted, we've seen progress in technologies. And I think that the experience of Ukraine in the use of digital technologies could also be involved. And we've seen cases where judges were using different digital technologies, including ChatGPT. And I think it's not feasible to limit lawyers in the use of digital technologies. But we must think about ways in which those technologies could be used so that we still keep the discretion of judges. But that is a question that could be discussed. I also think that if we follow the principle of the rule of law, then the issues of independence of judges, that is something that could be taken into account within the qualification assessment. I also consider it expedient to improve the testing, so that we see whether the candidates have understanding of the practice of the European Court for Human Rights, whether they understand the convention. Because the decisions of the European Court for Human Rights just interpret the articles of the convention, and it's important to see whether the candidate has an understanding of those norms enshrined in the conventions, which are implemented in the decisions of the European Court for Human Rights. And finally, what I believe could be improved in the work of HQCJ is for HQCJ to have a more proactive position together with HCJ. In Ukraine, the legislation changes very often. So in order to ensure the quality of selection, not to use any tests or approaches that may be outdated, the HQCJ must understand the trends in the amendments of legislation, maybe suggest changes to the tests, and using this experience while selecting judges, they can be on the forefront of the improvement of the system of judicial selection, not in the avant-garde. So that's everything I wanted to say.
All right, Mr. Sydorovych, I think in your opening comments, you probably answered a good number of the questions that my colleagues will have of you, but hopefully some questions will remain. And perhaps an obvious, I won't say concern, but a circumstance that your candidacy presents is the following. You may be familiar with the saying that politics is the art of compromise. And that brings me to a concern that has been expressed, as you will be aware, I'm sure, in many people, that in the past there have been allegations of political interference in the appointment of judges and the process of appointment of judges. And that brings me to my question. Do you still have associations or communications, or do you still have contact with politicians that, of course, you became acquainted with during your days as a deputy of the Verkhovna Rada?
Can I start answering?
Yes, please.
Well, first of all, it should be mentioned that based on the results of the assessment of Opora civil network, I was recognized as one of the best MPs in terms of integrity in the year of 2018, which speaks about the level of my integrity. If we are talking about my political activities, once I stopped being the People's Deputy of Ukraine, I stopped any political activities. I discontinued my membership in the political party with very simple reasoning, because I believe that involvement in the political life and being a lawyer did not correlate very well. That is why, starting from 2019, from September of 2019, I have not been involved in any political events, I have not participated in any political discussions, and I focus solely on my legal activities. I'm the national expert of the Council of Europe, I'm the national expert of Pravo Justice Project. And as far as keeping in contact with active politicians or ex-politicians is concerned, if I even wanted to keep those contacts, I wouldn't have had time for that. Maybe that's not absolutely correct, but I really don't have much time, so I watched only 2 of the interviews that you are conducted, so I physically don't have time for that. But it seems to me that the best example of my political neutrality and my principles of not allowing for any political influences is that when amendments were introduced into legislation, I supported the exclusion of 5-year probation period. It was my principled position, so I supported the amendments where politicians did not have any right to submit any disciplinary appeals with regards to judges. So everything that I was trying to do in the end was aimed at diminishing any political interference. And over the 5 years of me being a politician, I never made a single statement and I never wrote a single document that could be qualified as influence or pressure on courts and judges, or any kind of vested interest that I had in the judiciary.
You were a member of parliament for almost 5 years, and 3 years have passed since you no longer were a member of parliament. But are there still members of parliament now, today, that served as members of parliament when you were a member of parliament?
Yes, there are people's deputies like that, those representing the political party European Solidarity, the Batkivshchina political party. These are people's deputies from the Dovira group of deputies and the non-existent opposition platform for life.
And do you still maintain any contact with any of these former political contacts of yours?
No, I don't keep in contact with those deputies. Of course, if they call me, I'm going to pick up the receiver, but I don't keep in contact with them because there is no objective reason for that, to be honest. Maybe I had 1 or 2 meetings with people's deputies when, as an expert of private justice, I was invited to the meetings of the Committee on Economic Policy, where the discussions were held about amendments to the codes. And as an expert, I was presenting my expert opinion with regards to those legislative amendments. Other than that, I had no other contacts with them. And I'm sorry, I remember about one more occasion. A year and a half ago, I participated in the selection for a judge of the Constitutional Court of Ukraine, and respectively, I was invited to an interview to the Committee on Legal Policy. I was present during the plenary session. I was not appointed. I held the second place, so I was the runner-up in the competition. So practically, that's all the contacts that I've had with acting politicians.
All right, and let me ask my last question, and it's a bit more of a general question. I started my questions of you by indicating that we have heard the opinion expressed or the conclusion expressed that in the past there have been politicians, members of the cabinet or otherwise, that may have involved themselves inappropriately in the work of the High Qualification Commission of Judges, and in particular attempting to influence the commission. Are you aware of any such circumstances? And do you accept that that, in fact, might have been the case, or what view can you share with us regarding that concern?
It is my belief that before 2014, we had influences like that. I cannot provide you with definitive proof. Otherwise, I would have reported that to law enforcement. But in 2014, the HQCJ and the High Council of Justice were relaunched. But the following should be noted. It appears to me that an attempt of influence, either by the executive bodies or the law enforcement bodies, both on the HQCJ and HCJ, and including the judiciary trying to get this or that decision, I believe that we've had these attempts and we still have them. And they are rooted in the nature of the relationship between the different branches of government. And many academic papers were dedicated and have been dedicated to this topic. So as a lawmaker, what I was doing was to try and decrease the tools available to the parties to have this kind of influence. I understand that abuse and usurpation of powers happens not because of institutional capacities, but because specific people want to abuse power. And I can just refer to Hamilton and Federalist Papers, where he mentioned the dangers of the judiciary being too close to the executive and legislative powers, because that's a threat to democracy. So I think that only institutional mechanisms are not going to be enough to prevent such influences. It's also about the understanding of each particular member of HQCJ, HCJ, or a particular judge, that any influence or pressure upon them are unacceptable, because that destroys democracy. And it should stem from this kind of realization, not from some instructions, because even if we have enshrined it in the documents, but a person who sees this unduly influence does not report about it, then it's the democracy that is harmed. And here we must talk about the ratio of responsibility and freedom. Only a person who understands responsibility, because when we talk about freedom, freedom is about self-limitation. You must understand the consequences of the violation or offense that you have committed. So neglect for even minor things may result in destruction of institutions.
All right, Mr. Sydorovych, I think yes, I have your answer, and I think we understand the position that you stand for. I'm going to invite you then to answer the questions of my colleague, Judge Verlanov.
Thank you, Tad. Good morning, Ruslan. So I will continue with the topic started by my colleague Tad. So I have a question about political neutrality and influence. Influence on representatives of the judiciary, including influence on the members of HQCJ. From a practical standpoint, so let's assume you're an HQCJ member and you received a phone call from your former colleagues, from people from the political party Samopomich that you used to be a member of, asking you to have a closer look at a specific candidate judge. So what are you going to do in this situation? If I receive a phone call when I'm being told to pay specific attention to a specific candidate, then we have the anti-corruption laws, where the algorithm is prescribed on what we should do in such a case. But my life experience and my experience of working in the parliament tell me that most likely, if there's an attempt to influence me, either from my former colleagues from the political party or from incumbent politicians or any representatives of the executive government, any attempts of such influence are not really specific during the initial stages. When I started with my political career, some people started conversations with me and they discussed different general topics with me, testing out my responses. And I interrupt such conversations immediately, and by the first year of me being an MP, nobody came up to me with this kind of conversations. Thank you. So in your motivational letter, among other things, you mentioned that your dream is to see the Ukrainian judiciary as an example for many democratic countries in the world, as a branch of government where the rule of law exists. So in this example, which country or form of government do you see as an example for Ukraine political system? I don't think that there is a perfect model. I like the common law, the Anglo-Saxon systems, because of their consistent democratic traditions, but it doesn't mean that we can implement all of the democratic institutions existing in those systems. First of all, I don't want to devalue the existing Ukrainian experience, and in many aspects, Ukraine has been more progressive than the countries with established democracy. And the problem is not so much about the laws and procedures. It's about nepotism, kleptocracy, some influences of the executive and legislative government on the judiciary that we need to get rid of. So I remember me talking to the judge from the Supreme Administrative Court in Germany, and their judges are appointed using political will. And we had dinner with that judge, and I told him, so you were appointed under political quota. Is there any danger of political influence? And he told me, well, theoretically, I could receive a phone call from a politician, but I cannot even imagine a situation in which a politician could pluck up enough courage, pick up the phone, and call me asking for a favor. So I think that the traditions of phone calls from politicians coming from Hrushevsky or Bankivska Street, I mean those bodies of executive government, I think that we need to strive to have such a possibility become something unimaginable, unacceptable. If we interrupt these things at the very beginning, then the tradition will die out. Thank you. My next question for you. In your motivational letter, you also say that integrity is an indispensable factor, and with all due respect to psychological tests, you believe that an interview is an important stage in the selection. So, please, how do you understand what integrity is, and how is it possible to assess a person's integrity during an interview? Thank you. So you are actually asking me two questions with this question. So you're asking me about integrity and professional competence criteria. And these are two wings of the same bird. So it's not enough to only have integrity. You also need to have professional competence. So if we talk about integrity, my experience of recruiting people and my profound interest in psychology helped me by asking specific questions assess whether the person has integrity. But if we are talking about an interview, we are not talking about the stage outside of other stages in the process. So if a candidate has completed tests, has completed the theoretical test, they have drafted a court judgment, they have undergone psychological testing, if we have already assessed their materials and documents, then we can formulate those questions for the interview that will help us see how the person will behave in specific situations. So we can modulate some questions to see how a person will behave themselves in specific critical situations, because integrity is about how a person behaves under pressure. So after you've completed a number of stages, a number of reviews and inspections, you proceed to the interview where you will be able to assess integrity. Yes, you're absolutely right. So I would suggest having two interviews, one short interview based on the results of tests and drafting a court judgment, and then I would have one big interview similar to the one that we are currently having based on the results of review and inspection of available information. Why can't we have one interview? So I will disclose a small secret about how we are selecting people for our law firm. So we are conducting two interviews. We are having testing of theoretical knowledge. We give some practical tests. And it was not that we initially had two stages, but we saw with time that it helps us minimize the mistakes in our selection. Thank you. Thank you very much, Ruslan. I'm now passing the floor to my colleague, Yevhen Mezentsev.
Thank you, Sergei. Well, it's a pleasure for me to hear, Ruslan, that you're applying a differentiated approach to the interviews while selecting people for job, while hiring people. It's really a well-justified approach. For example, my son had an interview in an IT company, and at first he had this interview with an HR. After that, with the tech lead, performing some technical tasks related to writing a certain program code, and only after that he had an interview with the project manager. Let me inquire about the following. We have got the data saying that you participated in the selection to the Supreme Court. You have also mentioned today that you applied for the Constitutional Court, and it was not quite a success, as we can see it today. For yourself, have you made any conclusions as to what you lacked to take those positions in the high courts of Ukraine? Why did it happen so? Well, if we speak about the selection to the Constitutional Court, I lacked political neutrality. Or let me rephrase it. My political neutrality probably prevented me from getting the sufficient number of votes, because in spite of the fact that the whole presidium voted for me, 80 members of the Servant of the People and the whole EU, Batkivshchina faction, Dovira, Holos, more than a half of the party for for the future, but I got only 168 votes, which is quite a good result. But the candidate representing the pro-ruling party actually won. I guess that some MPs were concerned that I could be a person of principle and I would be politically unloyal to them when there will be the debate, that I will be politically neutral, will not be supporting them. As far as the Supreme Court selection is concerned, I lacked just some score points on the basis of the results of writing a practical assignment. I would rather discuss this matter in public with the man who was actually checking my paper, my practical assignment. Yes, but of course not within this selection process. Yes, sure. It would be actually of interest for me. I even wanted to have a public debate on that. I was not going to complain, to appeal, but there were some issues. The point is that I interpreted the actions of a certain shareholder as the abuse of one of the rights. And this had something to deal not with the restoration of the rights through appealing in the disputes between the shareholders, but I treated it as prevention of operation of the company and damaging the interest, bringing harm to the interests of the market. Okay, these are details. Let's not go deep into that because we can spend a lot of time on that. I would say that in the context of that selection, I would rather like to discuss it later, regardless of whether I'm elected a member of the HQCJ. And I would like to discuss about the methodology of assessing judicial decisions, because you need to identify the way of thinking of candidates and the ability to substantiate their grounds, their reasoning behind the decision. Okay, clear. We've got information from NABU that actually everything is fine with your property declaration, but there is one issue we paid attention to, and I think that it should be discussed in public. In particular, it has been indicated that your family, your wife, in 2020 bought Mazda 3. The car was sold out in 2022, and so far in your declaration for 2021, we didn't see any reference to this car. You've provided the explanation saying that the car was damaged within the insurance, and you were actually giving this car to the insurance company, and seemingly the insurance company bought it out from you in 2022, but it struck it off the register in 2022, and that's why this is the situation. But could you provide any details to how this happened and what were the documents under which you gave this Mazda 3 to the insurance company? And just to give some clarification, because it's a little bit bizarre. Well, sure. We should pay attention to the fact that alienation of the car was the process of 2 stages. And the documents were given to the buyer only at the 2nd stage, but now it's at the same time action. That's why the car was not struck off the register. But as the result, the car got into a traffic accident. My son was the driver. And what was the date of this traffic accident? At least the month. This is November. 2nd part of the year. And on the basis of the results of the examination of the car was acknowledged to be the one that cannot be repaired. And this is, of course, within the operation of the insurance company. And finally, the car was put to auction. And the results of the auction were shown by me in the documents. And I wrote the explanations that in December, the beginning of December, actually there was the winner of the auction and the car was sold out. That's why the car left, if I'm not mistaken, for Rivne region of Ukraine. And the man from whom we bought this car is an acquaintance of mine, and he told me that okay, why do I see that the car that has been sold to you is again at the auction? So, and the car was struck off the register only a year after that. I mean, the next year. That was done by the buyer. I have a suspicion that he bought the car just to resell it. And the person who bought the car was not in a hurry to re-register the car because he wanted just to find the buyer. So he repaired and wanted to resell it, right? Well, I cannot state it, but I think that most probably this is the way it happened. And since the car was alienated, that's why it was not indicated in the declaration. The wife got the payment from the insurance company. Okay, it's clear, and I accept your explanations. What do you think? Unfortunately, there are some cases when there is some pressure on judges via mass media, via some civil society campaigns, some other methods are used which are often illegal, unfortunately. What do you think? Would it be ethical for a judge to announce a self-recusal from the case in case there is some pressure exercised on him during the case hearing? Well, I would say it depends. Not necessarily. If there is some pressure exerted on the person, but this pressure has not reached a certain limit, the limit when the judge has some internal doubt concerning how he should settle this case in an objective way, so then I think there are no grounds for self-recusal. And this may be a threatening phenomenon because the fact of pressure could actually aim at the self-recusal of that judge. But along with that, if the pressure has led to the emotional status as a result of which the judge has lost the ability to objectively approach this case, he has got some fear that he will not be able to objectively make a judgment, and he is afraid of his fate or the fate of his family, depending on what his decision is, then probably there could be grounds for self-recusal, just to ensure proper administration of justice. Okay, and in the context you have mentioned, when there is a real threat to the life, and a person announces a self-recusal and shifts the responsibility on the other colleague from the same court. So another judge will have, again, the duty to consider the case, but there will also be the threat to the life of that judge. So would it be ethical, all the more that self-recusal statements are not appealed? So do you do it right in relation not to the proceedings but to your colleague? When you remove a threat for your life but you pose a threat for your colleague? Well, you're actually trying to shift your pain onto the other colleague who is also a judge like you are, and he is not to blame for the fact that you have come to dislike someone in a court proceedings. I've already mentioned Friedrich Hayek and his constitutional freedom, about the correlation of the constitution of the freedom and responsibility. So the judge should have as many virtues as possible. And from this point of view, this kind of behavior is unethical 100%. But if we speak about threat to your life, I know some judges, I personally know them, who, if threatened in reality, would just get confirmed in their own standpoint. They would anyway reach the final decision and thus affirm their judicial status as the status of the person who cannot be affected. I also know such judges in the appellate court in Kyiv. They have guards, but they don't announce self-recusals, and they hear the cases that really could pose a threat to their life. Okay, so let's go over to a rather controversial topic, and I would like to hear your opinion on that. There is a certain list of fundamental rights and freedoms. You definitely know this list because it's predetermined by the respective European Convention. And in fact, any of those aspects, any of the fundamental human rights or freedoms, if necessary, can be limited. And the Convention allows this to happen in case this is really necessary in order to ensure security, economic prosperity of the society, survival of the nation, and so on and so forth. But along with that, there is also a conventional rule or conventional right that is the right to prohibition of in degrading and torturing behavior. It cannot be limited. So why do you think that this fundamental right cannot be limited under the convention under any circumstances? Thank you for the question. That's what I was actually telling about when I was the candidate for the Constitutional Court of Ukraine. I drew special attention to it. Why dignity? Why prohibition of degrading treatment? Because someone can take the life of a person away in the conditions of martial law, under the war, or in some other circumstances when the judicial bodies are trying to detain a person in some other cases. But even if a person is deprived of life, a person cannot be deprived of the right to dignity. Why is this right so much important and so much fundamental and basic? And if I'm not mistaken, this Article 64 of the Constitution also tells about the same non-ability to, not being possible to limit dignity, the right to dignity. Because when dignity is taken away, freedom is taken away, and the right to be a human is taken away, and then this undermines the most important component of democratic order. A person who has lost freedom cannot pass free decisions, and hence democracy is all lost. And if we are so much dedicated to the principle of the rule of law and affirmacy of democracy, this fundamental principle cannot be violated under any circumstances, because without dignity, a person will never feel fairness and justice. Okay, it sounds rather convincing. Then what is your attitude to the ticking bomb? I mean that you catch a terrorist who put a bomb in some entertainment center or shopping mall. He can give you the data how to do demining, but he doesn't want to do this. And if you don't get this information from him under torturing, tens or even hundreds of people may die. But you have clear data that if you apply torturing, he will give away the information about the demining of this bomb. What is your personal attitude to that? Is it permissible, even in the conditions of the war, to apply such measures in relation to a person who has got the data that will help you to liquidate the disaster and the threat for hundreds of people? Well, that is an issue from the quantum physics about the wagon. It's the same story. It's, my populist view would say that, well, you should torture if you can save so many people. But there are two important aspects behind this. The first aspect is humanistic. If we violate this principle, and if we do it once, even for the sake of one great goal, it means that we will find it easier to deviate from this principle for the second time. The serious small law of small evil is actually the devil's theory. We either follow the principles or we don't follow them. You cannot be honest but violate principles once. And then how can you be 100% sure that he will give this data? No, but this is the condition, the precondition of this task, that he will. Okay. So let's treat it in the following way. My first idea was about the philosophical approach. It's saying that it's not possible to deviate from the principles at all, in no circumstances. This is nothing to be discussed. But if we go over to these pragmatic terms and speak about this in reality, I don't think that this can anyway ensure that the results are achieved. The BBC made a survey, and 59% of the people on the planet actually share your opinion. Thank you, and let me give the floor to my colleague Stephen.
Thank you very much, Judge. And thank you very much, Mr. Sydorovych, for participating in our competition today. I'd like to set up just a little bit of a foundation for the question that I'm going to ask you. I very much admire the motivation that you've shared with us and the thoughtfulness that you've demonstrated over the last number of minutes during this interview. And I particularly appreciate your comments concerning Alexander Hamilton, and you referred to his warnings that the judiciary must not come too close to exercising the legislative power, and he speaks for the separation of powers, and you have the same three separated powers in the Ukrainian constitution that many other countries have in their own constitutions. And you also speak about democratic traditions and institutions in your motivation letter. And you do so, always very thoughtfully. But there is a very polarizing and divisive legal philosopher in the United States. Many admire him, but at least as many do not. And that's the same philosopher you mentioned in the same paragraph, Ronald Dworkin. And Dworkin, according to his critics, and that's who I'm quoting from here, basically speaks for a new class, generally comprised of journalists and academics and Hollywood celebrities, the critic says, who are opposed to tradition, family values, religious values, and liberty at the expense of equality. Many people who criticize Dworkin say that his philosophy is one that tends very strongly to erode democratic values in favor of judicial decision-making, to replace legislative and executive decisions in favor of judicial decisions, to replace the rule of law by the rule of judges, to replace interpretations of the law and Constitution on the basis of text and history by moral philosophy, and to replace the self-rule and the self-governance and the self-representation of the people by judges acting as moral philosophers. I don't want to get too high in these issues today, but to me it's a pretty important issue. Do you see a tension, as I am inclined to see, between Hamilton and Dworkin, or are there other things that you see as being Dworkin's strengths? But you've got two people here who are almost as much in collision with each other philosophy as it's possible to imagine. And I'm just concerned, what kind of judges are you going to be looking to populate the future judiciary of Ukraine?
Thank you for mentioning another favorite author of mine, Mr. Dworkin. And, well, of course, we need to understand that when we speak about certain divergences between the Hamiltons and Dworkin's philosophies, because they are separated in time. And, of course, this imposes a certain context on all their philosophical ideas. But if we mention Mr. Dworkin, I'm sure that I can tell you that I've written one article recently about judicial activism and judicial restraint, their positive and the negative sides of them. And what I like is Dworkin's position in the sense where he says the following: the laws that are passed and the decisions that are passed by executive authorities could be of poor quality, imperfect. They even may aim at violation of some rights. And Dworkin, in his book, A Serious Look at Law, or something like this, says in section 5 that, well, probably I'm not going to quote, but he says that when I tell my children that they have to behave in a just and fair way. I definitely mean some methods, some ways of behavior, but I agree that my children can behave in a different way than I meant by this. But I will accept their explanations that they behaved still in a fair and just way, even if they acted in a different manner, if they managed to prove this, that they acted in a fair and just way. And he gives two reasons for this. The first reason is that, of course, he says, I cannot envisage that the rules I give to my children will embrace every single situation they get into. And the second reason is that I want my children to be guided by the concept of justice and not a specific notion of justice, just the strategy of justice. And that is a very complex issue and a very delicate matter. When we read their opponents and the supporters of judicial activism, we find that they were actually talking about one and the same thing, but they were approaching it from different angles. And a judge in his daily activity faces the challenges the legislator probably even didn't know of. He has got a specific case he needs to hear and pass a decision. And when we speak about the application of the principles of law, and without application of such principles, we are just degrading into positivism. So a judge must always be ready to reason his standpoint, to interpret the priority of specific laws or principles of the law over the other ones, because in several different situations, one and the same principle of law could be the ground for disciplining or for dismissing a person, or under other circumstances, that could be the reason for relieving a person from responsibility. So the judge should be ready to properly interpret the facts. And by the way, Hamilton, in his book, also writes that the judiciary should be ready to kind of restrain or curb the other branches of the authorities if they trying to encroach on human rights. But the most important challenge is to write this.
But Mr. Sydorovych, when you tell your Mr. Sydorovych, when you tell your children, stay out of trouble, I'm going to be out of town for the next week, stay out of trouble, you expect your children to say, what did Father mean by staying out of trouble? What were his intentions when he told us to stay out of trouble? What were the words that he used specifically when he said stay out of trouble? You wouldn't approve of it if they said, we don't really care what Father said. We don't really care what Father meant. We have the right to determine for ourselves what it means to be in trouble and what it means to stay out of trouble. And we respect our Father, but we're going to replace his judgments by our judgments. Wouldn't that trouble you a little bit?
Anyway, they will be using their own judgment. That's true, because you cannot extrapolate somebody else's judgment on your own judgment or otherwise. And that's the same way that the parliament cannot extrapolate its judgment on the judgment of a specific judge who is going to try to hear a case. But if this child of mine, or any child, or if we speak about the relationship between different branches of power, if this side can substantiate why this concept of judges, why this line of behavior and decision corresponds to this concept of justice, and it's rather convincing, this reasoning, I think that this can be acceptable then.
Well, let me ask you just a first principle then. What do you mean by the rule of law? We refer to the rule of law in our methodology, and it seems as if most jurists and academicians generally have a common understanding, but there's some room for flexible understandings and differences of opinion and reasonable judgments. What do you understand by the rule of law? And you're going to be a significant architect in the rule of law for the country of Ukraine if you're placed upon the High Qualification Commission. What are you going to be trying to facilitate in that regard?
Well, first of all, when we speak about the rule of law, there are different doctrines, and they are evolving, and that's good, actually, they are developing and evolving. But finally, the rule of law does not exist for one person, the same as courts do not exist for judges. Court exists for the sake of achievement of a very specific objective, which is protection of human rights. The most important, the fundamental and basic human rights in different situations.
I thought their responsibility was to interpret the law. I thought their first responsibility was to interpret the law, to look at what the Verkhovna Rada has said and to look at what the Constitution has said and to try to give faithful meaning to what those laws say. I thought that was the first responsibility of the court. Am I wrong in that?
Well, you're not wrong. That's really true. And if we speak about a bit of formal or textual approach, of course, we should more refer to the Venice Commission opinion where they established certain criteria. Well, I'm sorry, I feel a little bit sick. So they provided the list of criteria for the assessment of such notions like legal uncertainty, equality to the law, ban on arbitrary will, and it contains several questions, a certain checklist that allows you to assess certain actions as to whether they correspond to the rule of law principle. But even this opinion of the Venice Commission is not a sufficient document, I would say, to really embrace absolutely all the issues. If you ask me for a brief answer what the rule of law stands for me, I would say this is just common sense to a certain extent. Because if there is no common sense, there will be no rule of law, by definition.
Well, we could go on to this issue indefinitely, and we don't have the time to do that. And I appreciate everything you've said here so far, but I do want to conclude with a question. If you are placed on the High Qualifications Commission, and I know you'll do a very conscientious job, but are you going to be looking for moral philosophers, or are you going to be looking for outstanding and highly competent jurists?
I've already mentioned this analogy today about a bird being unable to fly without one wing. So a judge must have integrity, but they also should be professionally competent. Having only one of those qualities will result in the decline of the judiciary and a threat to democracy as such. It's not a compromise that we should be making. There cannot be any compromise in this case. If a judge lacks integrity, or a candidate judge rather lacks integrity, they cannot be a judge. If they don't have enough professional knowledge, then they need to continue training. They need to get some additional training. And I was really insisting that we raised the age from which we could appoint people as judges, because we used to have it at 25 years. Now it's 30 years. But even 30 years for me is too young, because there's the concept of theoretical knowledge, but also the experience of applying this knowledge to practice. And integrity when working as a lawyer or as a prosecutor can demonstrate to the society that this person can be appointed as a judge.
Okay, thank you very much, Mr. Sydorovych. I appreciate it. Let me turn over the questioning to my colleague, Mr. Brookhuizen, please.
Well, unfortunately, my colleagues didn't leave me any time to ask any questions, so I will avoid asking questions. That's a pity, because there are quite some subjects that have not been discussed with you. And I have one remark that maybe you can give an answer on in your final statement. And the remark I have is that on the page of your law firm, in the website of your law firm, it says that your law firm is about anger, and it is about getting great victories, and it is about very, very aggressive protection of your clients, leaving no chance to your opponents, and it's about achieving justice even in a hopeless situation. Where I'm very interested how you do this in Ukraine, achieving justice in hopeless situations. You know, of course, that I'm someone who is always busy with corruption, and I also know that politicians in Ukraine, they have an inclination sometimes to corruption. And if I read what it says on your front page of your website of your law firm, it says something about achieving justice even when that is impossible. And I'm wondering why you have this message on your website of your law firm, and how you achieve justice in hopeless situations, and how you achieve this without corrupt methods. But maybe you can answer it even when you have your last words. Back to the chairman, please.
So does he have to answer or no?
To you, chairman.
So let's consider it a question, right? Відповідайте, будь ласка.
Let me be brief. Being professional, insistent, and strong. So very often we have these cases which we did not have in previous court practice. And we are able to achieve the result solely by us getting to the bottom of things, discovering very many facts, including theoretical things. And this is what helps us in cases when the opponents have some significant administrative support, or maybe they have more financial support, but we don't give up. Because it's my conviction you can lose a battle, but then win a war.
Пане Руслане, ви були дотичні до
Ruslan, you were involved in many judicial reforms or aspects of the judicial reforms, because we are talking about one big judicial reform. So what is your opinion? Were they successful? Rather yes than no. But have we increased trust in the judiciary? I think that we have managed to increase trust in the judiciary, but people continue criticizing judges. And the editorial board of Wall Street Journal says that Ukraine failed to build a system that would ensure the rule of law. That's the article that appeared some days ago. Yes, of course, it's obvious that we're still having this problem, and we cannot say that we have managed to solve it. But if you ask me whether it has become better, yes, then I think it has become better. Can we do better? Yes. Is it about reviving trust or having at least a significantly high level of trust in the judiciary? Can we achieve it within a month or a year? Maybe not. But if we are talking about the revival of trust in the judiciary, there is another important aspect which we haven't touched upon today. That's the aspect of abuse of the problems that are concerning for the society by politicians. When I was a politician, I never allowed myself to criticize judges for the decisions that they were making. We have the opinion of the Council of Europe, which says that political criticism of judges is unacceptable. And if we had less of sweeping criticism on the part of political bodies, and if we had more constructive communication trying to solve those issues existing in this society, a number of issues, because lack of judges results in longer terms of court hearings. Will it improve trust in the judiciary? Obviously not. Are the courts to blame for that? Apparently not, but the politicians present it as a drawback of the judiciary. Or a political decision, a political body made a populist decision saying that we need to have a specific category of cases heard by courts, and then there is this huge workload because courts have to deal with those appeals, and then those decisions made by courts in this category of cases are not enforced, and again, the courts are to blame in the eyes of the society. So this is another aspect in which we could work to revive the trust in the judiciary. Let's be objective. There are many issues within the judiciary, but if we look at the other branches of the government, is everything great with them? We have many questions with regards to all of our branches of government. We are a young democracy, but if we look at trends, I think that the trend is positive.
Дякую вам за вашу відповідь.
Thank you. Thank you for your answer.
Якщо можна дуже коротко, ми з вами торкнулися цього питання, що
So, if you may answer my question very precisely. So, you mentioned that politicians criticize the judiciary, not just politicians. And you, as an active user of Facebook, may have noticed that long before a case finds itself in the court, the Facebook community already discusses it.
приблизно зрозуміло, яке рішення має винести суд.
And it becomes quite clear what kind of a decision should be made by the judge.
І от днями несеться
And
черговий скандал.
just recently, we had another scandal about searches conducted in the office of a famous IT company in Ukraine. Without taking sides,
На рівні Фейсбуку.
it appears that on the level of Facebook, people have made their decision.
Чи не здається вам, що
It has become all too clear for them. Don't you think that the role of social media in the formation of the image of the judiciary, among others, is one of those aspects that not too many people pay attention to? And what should we do about it? Unfortunately, I will not be able to give you a precise answer here because that's a really serious problem. Modern democracy is formed on the basis of representative bodies. Since I know a thing or two about electoral codes, I know how social media works, I know how targeting works. I know that artificial intelligence is involved. We can use different names here, but it allows for social media to influence public opinion on different things with regards to decisions that should be made by courts, with regards to a politician that should be elected as an MP or as the president, with regards to who should be appointed as the minister or who should be dismissed. AI, with its potential for targeting, has transformed into a phenomenon. And I do think that we need to have some philosophical and moral reconsideration of it. So you discussed ChatGPT and other digital technologies. So this is all about digitalization of our social life and how digital technologies affect the various aspects of our life. It's a very difficult question, but in fact, it's a great threat, not just for the judiciary, but for the democracy as such. Thank you.
Чи будуть запитання у колег?
Do you have any other questions, dear colleagues?
Наша співбесіда наближається до свого
Our
завершення.
interview is coming to an end.
Підсумуйте її, будь ласка.
Could you please summarize it? Thank you. Thank you for your time. Thank you for the questions that allowed me to express additional ideas. It's a pity that our final commissioner asked only one short question. It would be very nice to have a longer conversation with you, but I don't want to take more time because we have other candidates. I hope that the work of the selection commission will result in you picking those members for HQCJ who will improve the judiciary and, as a result, will make our country better. That's something that I really want. Thank you, Ruslan.
На цьому наша співбесіда завершена.
So this is the end of your interview. All the best to you. Take care and goodbye. Goodbye. Thank you.